Hello and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. Every single civil services aspirant should go through two important documents released by the UPSC. One is the syllabus, the other previous year's question papers. Syllabus tells you what to study. Previous year's question papers will tell you how to study, what sort of questions have been asked, so that you can understand the requirement of this examination. So please go through the syllabus and analyze previous year's question papers. Your preparation will be on the right track. Today in this lecture, we will analyze some of the most difficult questions asked from Indian polity in the prelims examination over the past few years. I understand. When I use this term difficult, it's subjective. What is difficult to me may not be difficult for you, and vice versa. But if we analyze the performance of the candidates, we can say that majority of these candidates got these questions wrong in the civil services prelims examination. In fact, some of the teachers also got these questions wrong, at least some of them wrong. The agenda is that by analyzing these previous year's question papers, you will be in a position to better align your preparation, the strategy for this exam, because PYQs are the most important sources of information for you, which will tell you, as I said, how to prepare for the civil services examination. How do you eliminate the mistakes which you make in the tests? For that, you should take as many mocks as possible. Unacademy is organizing the year-end, the last UCSE test of 2024, Unacademy Civil Services Championship Test, which means if you are preparing for Prelims 2025, please attend this test so that you can understand where do you stand. Because if you would have enrolled in our previous scholarship test, you would also remember that because of the massive volume of the students, our website also crashed. One way it is good because you get to compete with lakhs of aspirants and you will understand where do you stand in this competition. And even if you are not preparing for 2025, you're preparing for 2026 and onwards, even then you should attempt this test so that you get an idea about what sort of questions are asked in the civil services examination. And by attending this test, you can also win lots and lots of prizes if you're looking for these prizes. The link to register for the scholarship test is provided in the video description. Please register, please attend. It is for your benefit. Now let's get started and analyze one of the most difficult MCQs, polity questions asked in prelims over the past few years. This question on your screen was asked in prelims 2023 in essence. What does due process of law mean? Article 21 of the Constitution, it talks about a fundamental right. The state shall not deprive an individual of his right to life and personal liberty except according to the procedure established by law. But then the year was 1978. In Maneka Gandhi versus Union of India, the Supreme Court said we follow due process of law. Not just due process of law, we also follow principles of natural justice. To understand this question, you need to understand what is the difference between procedure established by law and due process of law. For example, I am teaching on Unacademy platform. Suddenly there is a knock at my door. The police is there to arrest me. I have right to life as my fundamental right. You're basically depriving me of my fundamental right. But this fundamental right is not absolute. If the executive follows procedure established by law, my right to life can be deprived. I can be arrested. I can be imprisoned. But whether the executive is following procedure established by law or not, this is where the test lies. I will approach the court. My lord, my right to life, Article 21, fundamental right has been violated. How will the court protect my fundamental right? The court will perform three tests. Test number one, is there a law? which justifies my arrest? What if the police says, we have arrested this teacher because he was teaching polity on Unacademy platform? The court will ask the police, is there a law which criminalizes teaching polity on Unacademy platform? If there is no such law, I will be set free, because there is no law which justifies my arrest. But what if there is a law which says that teaching polity on an Unacademy platform is a crime? Then the question number 2 that court will ask, is this law valid? But sir, what do we mean by validity of this law? I will give you 2 examples. For example, the police says, you are under arrest under Section 66 capital A of the Information Technology Act of 2000. I will approach the court. My lord, my right to life has been violated. The court will say, is there a law which justifies your arrest? Yes, there is a law, Information Technology Act of 2000, under which I have been arrested. Section 66 capital A. But is this law valid? No. Why? Because in 2015, in Shreya Singhal versus Union of India, the Supreme Court said this Section 66 capital A violates Article 19(1)A, which is freedom of speech and expression, and as such, it is unconstitutional, which means I have been arrested under an invalid law and I will be set free. This is one meaning of a valid law. Another meaning, what if, for example, the Karnataka police is arresting me because I have been in possession of some illegal, illicit notes, currency. And for that, the Karnataka legislature has passed a law which says if you are in possession of illicit, illegal currency, you are a criminal. I will challenge this before the court, saying you should not have arrested me. Why? Because this law is not valid. And what do we mean by validity of this law here? Because Karnataka legislature is not competent to pass such a law. Why? Because that is beyond the legislative competence of the state legislature. Why? Because that comes under union list. So if at all such a law should have been passed, it should have been passed by the parliament, not by the state legislature. So I'm arrested under a law, but this law is invalid. But what if I'm arrested under a law and this law is valid? Then court will perform test number 3. Are the procedures mentioned in the law followed or not? Procedures in the sense, if I am arrested, I should be informed of the grounds on which I am being arrested. And the multiple interpretations of the Supreme Court is that these grounds should be communicated to me in a written. What if I was arrested under a law which was valid, but the procedure was not followed? One example of that is, I was not communicated the grounds of my arrest in written format, which means third procedure has not been followed and I will be set free because the executive has not followed procedure established by law. But do you know what the problem here is? This procedure established by law protects me against the executive, against the arbitrary actions of the executive. Police, for example. If the police has arrested me without a legal backing, if the police has arrested me under an invalid law, if the police, which is the executive, has not followed the procedures laid down in the law, I will be set free, which means I am protected against the arbitrary actions of the executive when it comes to procedure established by law. But imagine for a moment that legislature has passed a law saying teaching polity on Unacademy platform is a crime. And this law is valid as well. Procedures have been followed as well. Will the court set me free? No. Why? Because the courts are helpless against the legislature. The courts will protect you against the arbitrary actions of the executive, but not against the arbitrary actions of the legislature. But in United States, you are protected not only against the arbitrary actions of the executive, but you're protected against the arbitrary actions of the legislature as well. And that is what we call due process of law, which means test number 4 will be performed by the US Supreme Court, by the US courts. Is this law fair? Are the procedures mentioned in the law just reasonable. That means in due process of law, the courts can also go behind the intention of the legislature. Is the intention of the legislature bona fide or not? Are the intentions of the legislature rational or irrational, arbitrary or not? That means in due process of law, you are protected against the arbitrary actions of the legislature as well as executive. If you understand the difference between procedure established by law and due process of law, let's look at this question. And first, let's eliminate the options. Due process of law, which is the Supreme Court's interpretation of the procedure established by law mentioned under Article 21. Is it in essence, is due process of law same as procedure established by law? No, sir, you have clearly proven it that it is different. Due process of law protects you against the arbitrary actions of the legislature as well as executive, but procedure established by law protects you against the arbitrary actions of the executive alone. And it was in this judgment itself, Maneka Gandhi case, that Supreme Court said we follow principles of natural justice. And what do we mean by principles of natural justice? I cannot be prosecuted without being heard. That's principle number one. Second, nobody should be the judge in his own case. That's principle number two. Principle number three, the authority will have to act bona fide, which means in good faith. That means the intention of the executive, intention of the legislature has to be fair. So due process of law, does it mean equality before law? No, that comes under Article 14. So the only two options left now are principles of natural justice and fair application of law. In procedure established by law, when the third condition is, are the procedures mentioned in the law followed or not? If they are followed, you will be kept in prison. If they are not followed, you will be set free. That means the test number third in procedure established by law itself is whether the law has been fairly applied or not. So fair application of law is included in procedure established by law. But in essence, what does due process of law means? It means principles of natural justice, which means the authority will have to act bona fide, in good faith. So the answer to this question is A, the principles of natural justice, and it matches with the answer key released by the UPSC. And this question, a lot of students got wrong. Luckily, not the students I taught. Another question. Consider the following statements. The Constitution of India defines its basic structure in terms of secularism, federalism, fundamental rights, and democracy. The Constitution of India provides for judicial review to safeguard the citizens' liberties and to preserve the ideals on which the Constitution is based. Which of the given statements above is or are correct? Constitution of India does not define basic structure. You would know basic structure is a judicial innovation innovated by the Supreme Court, a 13-judge bench of the Supreme Court, which ruled on the 24th of April 1973 in a landmark case, Keshavananda Bharati versus State of Kerala. Supreme Court said there is something called basic structure, which means Parliament has the power to amend the Constitution using Article 368 without altering the basic structure, without touching the basic structure, saving the basic structure. But what is this basic structure? That Supreme Court gets to decide. Supreme Court said previously, rule of law is part of the basic structure. Independence of judiciary is part of the basic structure. Primacy of Chief Justice of India in judicial appointments is part of the basic structure. Parliamentary democracy is part of the basic structure. Judicial review is part of the basic structure. Secularism is part of the basic structure. Federalism is part of the basic structure. Fundamental rights related to Article 21, related to Article 32. These are fundamental rights. Article 14, these are part of the basic structure. Democracy also. But does Constitution define basic structure? No. It is left to the Supreme Court. Supreme Court has the power to decide what constitutes basic structure. So statement number one is incorrect. Statement number two. The Constitution of India provides for judicial review. Now, this statement is incorrect. Again, this is a question which a lot of students, including some teachers, got it wrong. And you can just go through the YouTube lectures analyzing this Prelims 2020 paper, and you will see a lot of teachers making mistakes either. Because Constitution does not provide for judicial review directly, explicitly. In fact, judicial review is not mentioned anywhere in the Constitution. But we can trace this concept of judicial review by looking at Article 13 of the Constitution, or for that matter, Article 32, or for that matter, Article 226. Article 13, for example, Article 13, Clause 1. If there is a law which has been in operation prior to the commencement of the Constitution, can this law, which has been enforced prior to the commencement of the Constitution, can it continue even after the enactment of the Constitution? Yes, if it is in conformity with Part 3 of the Constitution, with fundamental rights. If not, it will be declared void. But who will declare it void? Not the legislature which has made a law, not the executive whose task is to implement the law, but judiciary. So we assume this power is with the judiciary. That's judicial review. Article 13, Clause 2. The state shall not enact a law to abridge, modify fundamental rights. And if you do that, the law shall be declared void. And the assumption is that it is the judiciary which has the power to review that law in case it abridges, modifies fundamental right. Article 32. In case your fundamental rights are violated, directly approach the Supreme Court. In case your fundamental rights are violated, you can approach the High Courts under Article 226, and the High Courts, Supreme Court, will review the action of the executive if they have violated your fundamental rights. So Constitution does not provide for judicial review. We can trace the concept of judicial review by looking at these three articles. So which of the statements given above is or are correct? D, none is the right answer. Let's look at the question asked in 2018. Which of the following are regarded as the main features of the rule of law? Any student of Constitution and law will tell you that under Article 14 of the Constitution, there is a concept called equality before law. And equality before law is nothing but the corollary of rule of law. Which means when you look at rule of law, immediately you can draw the inference that we believe in equality before law, which is considered to be a negative right. It has negative connotation because it's the limitation on the state. How? Equality before law is part of Article 14. Article 14 is a fundamental right. And fundamental rights basically are limitations on the powers of the state. Because what do these fundamental rights say? The state shall not deprive an individual of his right to life and personal liberty. The state shall not deny equality before law. The state shall not discriminate. The state shall not do this. State shall not do that. Limitations on the powers of the state. So what are the basic features, main features of rule of law? Is it limitation of powers? Yes, because it is a fundamental right, which means a limitation. Is it equality before law? Yes. Equality before law is the second corollary of rule of law. Is it liberty and civil rights? Because these are fundamental rights which deal with liberty of an individual. But are these responsibilities towards the government? People's responsibility towards the government? No. Fundamental rights are basically limitations on the powers of the state, where the Constitution imposes limitations on the powers of the state. That's what we call constitutionalism, which, according to the political theorists, John Locke, the government should be and can be limited in their powers. And the legitimacy of that government depends upon whether it is observing those limitations or not. If the government is not following rule of law, if the government is not adhering to the limitations imposed by the Constitution, don't we say that this government is violating rule of law? There is no rule of law in a particular state. There is no rule of law, for example, in Manipur, which means the limitations which are there on part of the government is not observing these limitations. So what is the right answer? 1, 2, 4. C is the right answer. Another question. Out of the following statements, choose the one that brings out the principle underlying the cabinet form of government. Cabinet form of government, which means although Article 52 of the Constitution says there shall be a President of India, Article 53 says that all the executive powers are vested in the name of the President of India. But you don't have to read Article 52 and 53 in isolation. You have to look at these two articles along with Article 74 of the Constitution, which says there shall be Council of Ministers with Prime Minister at the head to aid and advise the President, who shall act on that advice. Yes, the President may ask for reconsideration of that advice, but only once. If the same advice is given again, it's binding on the President. And in fact, this Council of Ministers, headed by the Prime Minister, they're collectively accountable to Lok Sabha, the lower house of the Indian Parliament. That's the parliamentary form of government. Or the kind of government that we see in Britain, cabinet form of government, where it is the Prime Minister and cabinet which is powerful, which is the de facto authority in India. Although de jure authority is with the President. But by fact, by the implications, it is the cabinet, the Prime Minister and the cabinet who takes all the decisions, and their advice is binding on the President. Why have we factored in, why have we implemented cabinet form of government or a parliamentary form of government? Because constitution makers, such as Dr. Ambedkar, he said, I wanted to prioritize accountability rather than stability. Because in presidential form of democracy, there is stability. The president will remain in office and complete the full 4-year term, even if the party to which he belongs does not have the majority in the US Congress. Doesn't matter. You have the stable government. You will run 4 years unless and until you are convicted or impeached. First impeached, then convicted. But in India, we adopted parliamentary form of government. Why? Because we wanted accountability rather than stability. We wanted this government to be accountable to the people. How? Through Lok Sabha. In such type of questions, you should first eradicate the ones which cannot be the answer. For example, is it a device for strengthening the hands of the head of the government whose hold over the people is in a state of decline? It's a very sweeping statement made. How can you say that the head of the state or the head of the government, his influence is in a state of decline? The influence is declining and waning day by day. Generalized sweeping statement will be incorrect. An arrangement for minimizing the criticism against the government? Really? Since when is criticizing the government unconstitutional or a violation of law? It's part of your freedom of speech and expression. A mechanism for speeding up the activities of the government whose responsibilities are increasing day by day? Even if the responsibilities are increasing day by day, but for that, have we adopted a cabinet form of government? If the responsibilities are increasing, we can have presidential form of government as well. But is it a mechanism of parliamentary democracy? By ensuring collective responsibility of the government to the people, which means to the people, to the house, directly elected by the people, which is the Lok Sabha. C is the right answer. Let's look at another question. In India, judicial review implies what? It's not mentioned under the Constitution what is judicial review. Because Constitution does not mention judicial review. But in India, judicial review implies what? The power of the judiciary to review all the legislative enactments before they are assented to by the president. Can you challenge a bill in the courts No, you can challenge an act. Which means the courts do not look at the hypothetical questions. Because if there is a bill which has been passed, but it is waiting for the president's assent, what if the president does not sign this bill, refuses to sign this bill, or sends this bill back? There are lots of permutations and combinations. So we will be, if we are reviewing such a bill, we will be looking at hypothetical scenario. And the courts do not believe in hypothetical scenarios. You can challenge a bill, review a bill, only after it has been signed by the president. It has become an act, the law of the land. So power of judiciary to review all legislative enactments before they are assented to by the president? No. Now there are other three, which looks confusing to you. The power of judiciary to review its own judgments given earlier in similar or different cases. Yes, Supreme Court, for example, has the revisory jurisdiction. You're not satisfied with the judgment of the court, you can file a review petition. Even then you are not satisfied, you can file another review petition called curative petition. So maybe D is the right answer. B, the power of judiciary to question the wisdom of laws enacted by the legislatures. If we are following procedure established by law, the courts cannot question the wisdom of the laws passed by the legislature. Even if we assume for a while that we follow due process of law, where the courts can also look at whether the laws are just, whether the procedures are reasonable, fair. So maybe this can be the answer. But A option, the power of judiciary to pronounce upon constitutionality of laws and executive orders. This is the most appropriate answer. The reason I picked this question is, number one, a lot of students got it wrong. Number two, to tell you that you may find in a particular question that there are more than one statements which can be assumed to be true. Even there, you have to pick the most appropriate answer. And the most appropriate answer for judicial review is A. Why? Because judicial review means any action of the executive, any law passed by the legislature, the courts have the power to pronounce whether these are constitutional or unconstitutional. Yes, this is also right. The power of judiciary to review its own judgment, review petition. But the most appropriate answer is A. Sir, why not B, the power of judiciary to question the wisdom of the laws enacted by the legislatures? Because if we follow procedure established by law, then you can't question the wisdom of the laws passed by the legislature. But if we are following due process of law, maybe you can. But at the same time, we need to understand that judicial review means review of acts, review of actions of the executive and the legislature. That is why we say A is the right answer. And in fact, this is the answer provided by the UPSC key as well. A legislation which confers on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of application of law violates which one of the following articles? Article 44 talks about Uniform Civil Code. Can't be the answer. Article 32 talks about a constitutional remedy. That if your fundamental rights are violated, you can directly approach the court. Article 28, it talks about whether religious instruction can be imparted in educational institutions or not. So B cannot be the answer. Now the question is between 14 and 32. What is Article 14? Equality before law. What the Supreme Court has said, under Article 14, there is another right called right against arbitrariness. What is this right against arbitrariness? One example that I frequently cite. If I will tell you that those who had joined the class in the first 15 minutes, you can't ask me any question. But if you have joined the class from 15 to 30 minutes, you can ask me 10 questions. And those who joined the class after 30 minutes, you can never ask me any question. My decision to segregate people on the basis of whether they can ask me questions or not is arbitrary without any logic. If I would say, if you are from engineering background, you can ask me 100 questions because you're a poor engineer. But if you have a background in law, you can ask me only one question because maybe you just want to clarify a concept, otherwise you know everything. So if I can categorize students on these grounds, on the level of their preparedness, I'm making a reasonable classification, not an arbitrary classification. Right against arbitrariness is an integral part of Article 14. And if the executive is given unrestricted discretionary power, you can do whatever you want to do, it tends towards arbitrariness, which would violate Article 14 of the Constitution. Yes, if it violates Article 14, you can approach the court under Article 32. So then, sir, is it 32 or 14? But it violates Article 14. You can approach the court under Article 32, but it violates Article 14. That's what the question is asking. Violates which one of the following articles? Article 14 of the Constitution. Let's look at another question. Which of the following are not necessarily the consequences of the proclamation of a president's rule in a state? Under Article 356, when the president proclaims president's rule, the immediate casualty is Council of Ministers headed by the Chief Minister dismissed. Is the legislature dismissed? Legislative Assembly dismissed? No. Is it dissolved? No. It is kept under suspended animation to just find out whether a new government is possible or not. It's only when new government is not able to be formed, then the governor dissolves the Legislative Assembly. But immediately it is not dissolved. And we have seen after president's rule is revoked, the government gets formed from the same Legislative Assembly. For example, Maharashtra. So which of the following are not necessarily the consequence of the proclamation of the president's rule? Dissolution of the state Legislative Assembly? Not necessary. It may happen, it may not happen, but it's not necessary. Removal of the Council of Ministers? It is a consequence. Immediate casualty. Dissolution of local bodies? President's rule has nothing to do with the local bodies. Panchayati Raj institutions and urban local bodies, they survive, they continue. Question is asking, which of the following are not necessarily the consequences? 1 and 3, B is the right answer. These were the questions that we had to discuss today. Some of the difficult questions asked from Indian polity over the past few years. But as a civil services aspirant, please go through previous year's question papers and syllabus. Again, syllabus will tell you what to study, but previous year's question papers will tell you how to study, how also to anticipate questions that can be asked in the examination. Because if there was a question asked on the ethics committee of the parliament, it was because a particular member of the parliament was expelled based on the recommendations of the ethics committee. If there was a question asked on Official Secrets Act in 2023 prelims, it was asked because this law was passed in 1923, 100 years of Official Secrets Act. If the question was asked on the lapse of bills upon the dissolution of Lok Sabha, it was asked because this year Lok Sabha was dissolved after completing 5 years. So you should also anticipate questions that can be asked in the examination. And if you think that this video was of some help to you, please let me know in the comment section, and do not skip this video without liking to this video and subscribing to our channel if you haven't yet. Thank you for watching. Goodbye.